Hi friends, my name is Mallari Srinivasu. I work as Associate Vice President HR and Head of Manufacturing HR for Granules India Limited, which is a pharmaceutical company based out of Hyderabad. I earlier worked in companies like GlaxoSmithKline, Johnson& Johnson and Dr. Reddy's, primarily in the manufacturing or factory space, and have deep understanding and knowledge of ER and the statutory compliances and the employment law in our country. And many of my friends have asked me to start sharing some of the knowledge which I have gained over a period of time. And I have my own vlogs called Malladi Vlogs, in which I keep sharing. I have done some of videos in Telugu, and some of my North Indian friends who don't understand Telugu have asked me to do the same in English. And today I am bringing in front of you my analysis and interpretation of the recent changes in the industrial law, especially the Industrial Relations Code 2020, which has been notified by Government of India. While there are many videos in the net and many presentations which are circulating, given my own experience, I am trying to call out most of the tactical and strategic points which will be of use to ER professionals, and that's where probably you will not find that every small detail has been captured, or every small detail which is a difference from the earlier law has been captured, but the major issues which have a lot of importance and a lot of tactical and day-to-day strategic importance have been called out in my video. Please go through the video in totality so that you don't miss any of the important points which I'm trying to emphasize here. So let's start this video and let's know more about the Industrial Relations Code 2020. Over the last 5 years or so, the Government of India has been trying to bring about labor reforms, primarily in the labor laws governing our businesses in our country. While the effort has been going on for quite some time, it's only in the last 1 year or so that the Government of India has been able to push certain reforms after both the houses of parliament have passed the major labor codes. As you would know that in our country there are close to 30 to 35 different laws governing industrial relations or factory operations. And it's a noteworthy effort that government is trying to consolidate all these laws into 4 major codes. And recently government has notified 3 codes. One among them is the Industrial Relations Code, which is of great importance for the day-to-day ER, IR for all of the HR professionals who handle unionized workmen in our factories. To put it simply, this Industrial Relations Code is nothing but a consolidation of 3 major laws, which is the Industrial Disputes Act 1947, Trade Unions Act 1926 and Standing Order Act 1946. While all these 3 laws date more than 60 to 70 years, what government has now tried to do is consolidate them and bring into a one integrated industrial relations code. At a very top level, you would find that it's a consolidation. Definitely, we used to have earlier 3 different laws that has been now condensed to one law, but the provisions still remain more or less same in terms of the many sections running close to 120 to 130 sections which were there in these 3 codes have now been condensed to about 100 codes. So more or less the sections remain. Only thing is some of the key changes have been notified which are welcome from an industry standpoint. And let me start from the definition clause. For the first time, in the earlier Industrial Disputes Act, Section 2S defines workmen, and for the first time, the term workman has been replaced by term worker. Nothing great, nothing different, because it continues to talk about any person who is doing any skilled, unskilled, technical, clerical, supervisory, administrative job. The only difference is it includes earlier definition. Any supervisor drawing 10,000 rupees as a gross salary was excluded from the definition of worker. Now, every supervisor who is drawing 18,000 basic plus DA has been included in the definition worker. Now, from an earlier definition of gross salary, it has now come down to a definition of basic plus DA. Now, this has a lot of implication because in a lot of companies where the basic tends to be low, lot of frontline supervisors or frontline executives would perhaps come into the definition or consideration into the industrial relations code. So any person doing a supervisory job and getting less than 18,000 basic plus DA is now covered under the term worker, which is one of the major changes from an earlier definition which was based on a gross salary. The second important thing which in the definition part which I would call out was the type of workmen earlier were limited to permanent, temporary, casual, probationer, apprentice, and in some cases badali. Now the first time the Industrial Relations Code introduces the term fixed term contract as one of the kinds of workmen or the kinds of worker to be precise. Now the advantage here for the companies is, you can still employ a lot of people on fixed term basis for whatever duration it suits us, and you can also always terminate them after the expiry of the contract. It would not come under the definition of the retrenchment. So government has brought in a lot of flexibility in terms of bringing fixed term contract employees within the purview of the act and within the definition of the term worker. While they have done that, as a fixed term contract, they have created a new category of workmen. Some would argue that this would give a lot of flexibility and perhaps a lack of job security to the worker. A welcome provision here is in terms of gratuity entitlement. Earlier, as you all know, it was for 5 years. Unless somebody works for 5 years, you would not be entitled for gratuity. For the fixed term employees though, the government has reduced the term for 1 year. That means even if a person works for 1 year, whatever the gratuity he or she earns for that 1 year will be paid, which was earlier only he was entitled for a period of 5 years. So this is again a welcome provision from a workman's standpoint. Another important definition from a point of flexibility and something which we all feel day in and day out, retrenchment. Now earlier, in the definition of retrenchment, termination for continued ill health is no longer considered as retrenchment. We would all agree that especially factories which have been running for 30-40 years, we would have a lot of aging workmen who would have some of the health issues, and termination on account of continued ill health has been excluded from the definition of retrenchment. This is again a welcome provision and something where, in case a workman is suffering from prolonged illness, the management can very well terminate on account of fitness, and that would not constitute retrenchment, and there are no implications to pay retrenchment compensation. I think that's again an important change because earlier retrenchment did not include termination on account of continued ill health. Another important provision which I would call out now is the grievance redressal committee. Earlier, for companies employing 20 or more workmen, we need to have a grievance redressal committee, which many companies do have. The members in a grievance redressal committee were limited to 6, 3 from the workman side and 3 from the management side. Today, the number has been increased from 6 to 10. Probably this kind of a measure will help to more broad base the decision making process and involve more people in the grievance redressal committee. The other things related to grievance redressal committee in terms of the representation of women and all continue to exist even in the new code. Another important provision related to grievance redressal committee, I think earlier, in case of any of changes, we all know that a notice of change under section 9A has to be given. But the change or discontinuation of shifts also was part of section 9A of Industrial Dispute Act. That is, in case you had to change the shift working, you had to alter the shift working, you still had to serve the mandatory notice of 21 or 42 days under section 9A as per the relevant state. Now, I think maybe due to the experience of Corona, because many companies have run different shifts, mostly 12-hour shifts, and many such flexible models, especially to reduce the footprint. So the first time the government has given a enabling provision in grievance redressal committee that in case of any extraordinary situation, the changing of shift working can be done if it is approved by the grievance redressal committee, which means that in case the shift working has to be changed, if the grievance redressal committee agrees to it, you could still go ahead and do that and not wait for the mandatory 21 days and serving a notice of change. That's again a welcome provision and something which gives a lot of flexibility in our day-to-day operations. But there also is a catch here. Earlier, all the decisions or all the grievances which were referred to grievance redressal committee, the committee used to take decision by a majority. The first time, what they have done is they have put a mandatory clause in which at least 50% of the workmen representatives have to agree for the decision to be passed by the grievance redressal committee. So just to put it easily, earlier for example, if there were 6 people, 3 from the management and 3 from workmen, if let's say one of the workmen kind of sides or agrees with the management decision, you could still pass the decision or resolve the grievance by a majority of 4:2. But now they have put a condition of the majority of the workmen representatives have to agree for the closure of the decision or the decision which is taken in the grievance redressal committee, which means at least 3 out of the 5 workmen representatives of the grievance redressal committee have to agree for a decision. Another one of the major important provision, friends, which we all need to know and which makes a lot of importance for us on a day-to-day operations, especially in a unionized environment, is that of a negotiating union. Under section 14, for the first time, a negotiating union concept has been introduced in the Industrial Relations Code. Now, this negotiating union will be the sole bargaining agent within the industrial establishment. A related provision, just to add on, is the recognition of trade unions in India is not governed by any statute. Though Trade Union Act does exist, Trade Union Act only talks about the registration of trade unions and the different aspects related to formation, working and dissolution of the trade union and some of the privileges which the trade unions have. For the first time, a negotiating union is being recognized under the law. In many states like AP or Telangana or many states, the recognition of trade unions was only under a code of conduct. It was a model code of conduct which all employers and unions signed off or agreed because they need to have a bargaining union as a sole representative within the factory. Now, for the first time, the negotiating union or the recognized union is getting a statutory status. That's one of the important aspect because now the recognition has a statutory force. Though in other states, the only parallel is in the Maharashtra, where you have Maharashtra Recognition of Trade Union and Prevention of Unfair Labour Practices Act, which is called the Mrityu Pulp Act, as you would know. It's only in the Mrityu Pulp Act there is a provision of recognition of trade unions. In all other states, we have not seen any statutory provision for recognition of trade unions. That's for the first time being incorporated under section 14. But having given a statutory status, it's also added some amount of controversy here, which could be very tricky from a day-to-day operation standpoint. And the reason is for a union to be recognized as a negotiating union, it needs to have 51% strength of the muster roll of that establishment. Now, in my experience, what I have seen, and probably you would agree, that it's very difficult for one union to get a 51% majority in any verification or a recognition process. And the reason being that many of the hardcore IR dominated industrial establishments or companies which are surviving for more than 30 to 40 years have at least 2 to 3 unions in the factory. Now, when you have 2 to 3 unions, for a single union to get a majority of 51% would be very tricky and a very difficult job. From a day-to-day IR standpoint, it would definitely complicate the life of a factory HR manager, because you would not probably have a sole negotiating union. And though the law tries to clarify it and says in case no union secures 51%, the law does allow under section 14 in terms of an enabling provision, where it says that every union which got 20% or more shall get one person as a representative in a negotiating union. For example, if let's say there are 4 unions, I'm assuming each gets 25% or 30 to 20%, you would probably have a negotiating union comprising of 3 different unions with 3 different ideologies and 3 different perhaps an external leaders backing them. Now, from an actual day-to-day operations, this is quite cumbersome, because it's always easy to deal with one union as a sole bargaining agent or a sole negotiating union. If you have more members from different parties, generally to build consensus or to arrive at a decision becomes slightly more cumbersome and more complicated. But that's the provision of the law, so we need to respect it. But that's how the provision has been kept in the new Industrial Relations Code. Another important provision related to unions is normally in many of the places where the recognized unions do exist, the unions keep on asking for certain facilities to be provided in terms of a meeting room, in terms of a union office, in terms of many of those privileges. But the law doesn't, the existing Trade Union Act or the Industrial Dispute Act nowhere mentions about what are the facilities to be provided for the trade union. For the first time, Industrial Relations Code does talk about that the facilities to be provided for a negotiating union will be specified. Though they have not specified anything in the Act, but I am hopeful that there will be rules in which those details will be given. Now, related to the standing orders, as you all know, earlier the Industrial Employment Act or the Standing Orders Act was applicable for every establishment which had 100 workmen. Now the ceiling is being increased from 100 to 300. Again, less than 300, perhaps you can probably get away with having your own disciplinary mechanism and having your own rules rather than going through the standing orders certified or the model standing orders. It does retain the provision related to model standing orders, that in case the standing orders are not certified, you can still continue to have the model standing orders as like the earlier act, and the same provision is continued here. The only notable change is, as you know, the certification of standing orders is bit of a lengthy process, wherein you submit 5 copies of the draft standing orders to the Labour Department. They would then serve on the workmen or the union, and then the union would come up with their own observations or objections to that. Then both the parties are reconciled, and finally you get into a certified standing orders. But in my experience, and I'm sure fellow colleagues would agree with me, this process has been very cumbersome and very lengthy. Now, for the first time, I think government has been quite considerate about this, and they have put a provision in which they say that in case within 60 days the draft standing orders are not certified, after the expiry of 60 days they will be deemed to be certified. So this will definitely ease out a lot of process, lot of administrative hassles and lot of administrative delays which will normally have in certifying the draft standing orders, and perhaps this is for the advantage of all the parties involved because the process is now hastened. That's about the standing orders. Again, other provisions related to the discipline and stuff, they do continue in the act, the new act also. Friends, we all know the wage settlement, the tripartite wage settlement which happens. Nothing changes except that we all have been habituated to say it's a 12-3 settlement, 12-3 settlement. Now 12-3 has been changed to 53-3. Nothing changes greatly. 53 has the powers of the conciliation officer, which earlier were incorporated in ID Act under section 12. So a 12-3 settlement would now be called a 53-3 settlement under the new code. The terms broadly are the same. There is nothing much which changes. Another important provision under section 53 has been that, now you all know that earlier, whenever the conciliation fails, the conciliation officer normally sends out a report to government, broadly stating what is the dispute, what actions he has taken for resolution of the dispute, and according to him why the dispute or why the settlement could not be arrived at. The report continues to be the same which the conciliation officer submits, but a welcome change is that a copy of the report now has to be submitted in addition to the government to both the parties, which is the management or the workmen or both the disputing parties who come for the conciliation. So I think this is a welcome change, because at least we would be knowing what the conciliation officer or the labor department thinks about a particular dispute, and that's a welcome provision and a welcome change from an earlier scheme of things. Now, if we go to the next provision related to strikes, as you all know, earlier the strikes and lockouts were broadly categorized under two different provisions, one under section 22 and 24, especially those related to strikes and lockouts in a public utility service and those related to strike and lockout in a non-public utility service or other industries. And for the first time, the term public utility service, which was under section 2N of ID Act and under schedule 1, is now being abolished. That means there is no differentiation in terms of a public utility and non-public utility service, especially as regards the strikes and lockouts. A mandatory 14 days notice is required whether you are a public utility or non-public utility industry. That means that classification itself has been completely abolished. So any industry where the workmen have going for strike, or if the management wants to declare a lockout, a mandatory 14 days notice is required, which is quite different from an earlier standpoint which was only there in the public utility service, and a non-public utility industry could go for a strike or lockout at the brink of a notice or at the brink of a issue. So that's an important change in terms of the abolition of public utility service status and a mandatory 14 days strike notice for all industries. Another important provision, friends, you all know there are two important chapters governing layoff, retrenchment, closure, which were there in chapter 5A and 5B. Nothing changes much. Chapter 5A now becomes chapter 9 and chapter 5B becomes chapter 10. That's the major change, and that's the change of the chapters or the numbering of the chapters which changes. In addition, earlier the limit or the number of workmen which was there for an industry to be governed under chapter 5A or 5B was 100 was the threshold. That 100 has been now enhanced to 300. So in industries who employ up to 300 workmen, the layoff, retrenchment and closure can happen very easily without reference to government. This has been one of the long pending demands of the industries to raise the threshold limit from 100 to, though they were demand to raise it till 500, but some states have already done up to 300, and I think in the Central Act also they have retained to 300. So any industry employing up to 300, lot of operational flexibility in terms of the layoff, retrenchment or closure which has been given. Barring that, the provisions continue to be same in terms of the definition of continuous service or the compensation which has to be given for retrenchment or layoff. They continue to be same. Another important provision, friends, in case of retrenchment, for every retrenched workman, 15 days wages has to be deposited for a fund which is being constituted now called Worker Reskilling Fund. The idea of the government seems to be that in case there is a retrenchment which happens, the concerned industry deposits 15 days wages, which is nothing but basic plus DA. So 15 days wages has to be deposited with the government for every retrenched worker for reskilling fund. This is a welcome step. Any effort by the government for reskilling is always beneficial for industry to increase the talent pool or increase the capability of the workforce. Another important provision, friends, since we spoke about wages and retrenchment compensation, Now, earlier, the average wages which was being called out for the retrenchment compensation or for many of the definitions was gross wages. But for the first time, I mean, it's again a provision which is coming from the Social Security Code, wherein the definition of wages includes only basic plus DA. And for the first time, the 50% of gross wages has to be basic plus DA. This has been a mandate from the government, which is coming both from the Social Security Code or the Code of Wages, which was notified earlier. The same is there in the Social Security Code. The same is being now coming under the Industrial Relations Code. The tactical importance of it is normally whenever the settlement happens, the division of CTC between basic and allowances is always a contentious issue, because the workmen would want to keep more amounts in basic and DA, because that would probably give them more retirement benefits in terms of PF and gratuity. And the management resists that because it tends to increase the cost and also tends to increase the actuarial valuation, which will increase the cost indirectly. But it has been now been mandated that at least basic plus DA or the wages should be 50% of the gross wages. Any wages which is exceeding the 50% will automatically be added back to basic plus DA. That's a provision which they have kept. Again, last about three to four important provisions. Normally, whenever during wage settlement period or whenever the relations between unions and management go for a toss, normally unions resort to certain tactics, and this is the important provisions from a tactical standpoint. And one of the tactics they employ is, they tend to go for mass casual leave. Now, in this case, what happens is, though they are going for mass casual leave, it's very difficult to kind of prove it as a strike, because there would not be any notice, and not that everybody is acting in a concerted manner or staging a protest in front of gate. But people are absenting en masse, and managements tend to suffer loss of production due to such a certain situation. Now, for the first time, any situation in which 50% or more workmen absent or apply for casual leave, it has been included in the definition of strike. So, in case 50% of more workmen apply for casual leave, it can be termed as strike, and appropriate measures can be initiated by the management under the Industrial Relations Code. Similarly, another important provision, especially again during a strained relationship, is workmen or union going for go slow. Now, we know that the production is falling, the normal ways of working are not being adhered to. There is a dip in production because people are resorting to go slow. But what constitutes go slow, or how to prove that yes, union is deliberately trying to hamper the production and hamper the actual working of the establishment, is something which managements find it difficult to prove. For the first time in the Industrial Relations Code, go slow has been defined. And what is the definition? In case the average production is less than the 3 months average, you can term it as a go slow. For example, if your 3 months average production is X, and now you are continuing to getting something less than that X production, you can always prove it as a go slow under the Act, and you can always initiate either conciliation proceedings or any other remedy which is available in the Act. So, go slow also has been defined. Mass casual leave has been included within the definition of strike. These are some of the two good tactical and important provisions for the management. Again, from a unions and management relations standpoint, another important provisions, friends, is that normally when the union commits breach of settlement, we would normally, in my experience, I have seen we issue a letter to union saying that this is the provision under the settlement, you are violating it, and probably in case we want to further pursue, we probably give a complaint to a labor department and things like that. For the first time, a fine is being imposed for a breach of settlement, and this fine can range from 20,000 to 2 lakh rupees. I think this is one of the deterrent provisions for the unions, because normally when management gives a letter saying that you are violating the provision, why should I not impose a fine of, let's say, 2 lakhs or 1 lakh rupees, the unions tends to get a bit jittery, because that's the amount they would probably feel that they would incur, because management is now telling them officially. Earlier, the fines under the Industrial Dispute Acts were pretty minuscule. Now, for the breach of settlement, the fine can range something from 20,000 to 2 lakh. This is again from serving as a deterrent to the unions from violating the terms of settlement, which is again a welcome provision. And lastly, I would want to call out is that earlier, for adjudicating the labor dispute in addition to conciliation, they were basically labor courts and industrial tribunals. Broadly under Schedule 2 of the ID Act was the labor court, and Schedule 3 was the terms under Schedule 3 were for the industrial tribunal. The first time the government has abolished this distinction, and there will only be tribunals who will be dealing with all the labor disputes or labor cases, and no two parallel or two concurrent bodies like labor court and industrial tribunal, which were existing earlier, are now abolished. There will only be industrial tribunals who will be adjudicating various issues, whether be it in terms of the standing orders or strike or lockout, or any of the issues like the wages, the mode of payment, rationalization, the entire gamut of things would now normally be coming under industrial tribunal, and the distinction between labor court under Schedule 2 and industrial tribunal under Schedule 3 of ID Act is now going. So that's again from an administrative point of view, you have only one authority now to approach in addition to conciliation. So this is again one of the changes in the new Industrial Relations Code which has been notified. Finally, friends, though everything has been, the new code has been notified, it has been gazetted, the effective date of it has not yet been communicated by the government, because though the act has been notified in the gazette, the effective date in which the provisions of the act would come to force have not yet been notified. And perhaps one of the major reasons cited is that the rules are yet to be framed. As recently, I think we are hearing that the rules might have released. So I think once the rules are out for discussion, probably the government wants to notify all the 4 courts at once, sometime from December or January, and they are placing the draft rules for discussion. So though all the provisions are being notified, so we are still governed by the old ID Act and Standing Orders Act and Trade Union Act, because there is still time for the new Industrial Relations Code to come into force. So friends, thank you very much for your patient viewing. I hope I have been able to cover the major provisions. As I told you, the intention was to cover only the important provisions which make day-to-day and tactical relevance for all of us as working HR, IR professionals, especially in the factory space. So those have been covered, and in case you require any provision to be elaborated in much more detail, feel free to comment or reach out, and I will be glad to answer that. And in the coming days, other 3 codes also will be detailedly explained in terms of the differentiation from the previous enactment. Thank you once again for watching Industrial Relations Code discussion by Malladi.